Be ready. One, two, three, start. These 17 appeals are directed against an order of the learned single judge who had dismissed the writ petitions wherein the validity of the Land Acquisition Act and the acquisitions made thereunder were challenged. Stop para. Within the municipal limits of Jaipur, there are two villages named Bhojpura and Chak Sudarsanpur. Stop. Lands belonging to the appellants were notified for acquisition by the state of Rajasthan for the planned development of the city of Jaipur to the behest of the Urban Improvement Board. Jaipur. Stop. On 29/7/1959, the chairman of the UIB visited the site accompanied by the land acquisition officer Mr. K. C. Gupta and passed verbal orders that steps be taken for its acquisition. Stop. On December 8th, 1959, the Secretary Local Self-Government, was requested to issue a notification under Section 4 of the Rajasthan Land Acquisition Act 1953 within bracket hereinafter called the Acquisition Act bracket close. Stop. A notice under Section 4 of the Acquisition Act was issued on May 13th, 1960, which was published in the Rajasthan Rajpatra on June 9th, 1960, no objection was made under Section 5A disputing the existence of the public purpose as notified in Section 4 of the Acquisition Act. Stop. Accordingly, a notification under Section 6 of the Acquisition Act was published in the Rajasthan Rajpatra on May 11th, 1961. Stop. Soon thereafter, on July 18th, 1961, notices under Section 9 of the Acquisition Act were issued to the persons interested. Stop. 65 claims were presented before the land acquisition officer, including the one by the predecessor in title of the appellant Surajmal. Stop. The officer made an award on January 9th, 1964, which is Exhibit R/3 on the record. Stop. It was amended on July 9th, 1964. Stop. Early in 1970, notices were issued to the appellants to take compensation, hand over the possession and further to take possession of such parcels of land which were allotted to some of them. Stop. This is Exhibit 3 in Surajmal's case. Stop. Similar notices were issued in other cases. Stop para. 28 petitions under Article 226 of the Constitution of India were presented challenging the notifications issued under sections 4, 6 and 9 of the Acquisition Act, mainly because they were violative of the fundamental rights of the petitioners. Stop. In two petitions, from which appeals numbers 323 and 324 of 1971 are before us, even the award Exhibit R/3 given by the land acquisition officer was assailed and sought to be quashed. Stop. Para. The state of Rajasthan and the UIB, which had by then become the Urban Improvement Trust, by their joint answer, while admitting the salient facts regarding the issuing of notifications, contested each and every ground raised by the petitioners. Stop. They advanced additional pleas against the petitioners on the grounds of daily estoppel and res judicata. Stop. Para. The learned single judge found that the petitioners were guilty of inordinate delay and that there was no reasonable ground to condone the same stop, holding that the writ petitions could be dismissed on this score alone, he however examined the contentions of the petitioners and held that there was no force in the plea that the acquisition of the petitioners' lands should have been made under the Rajasthan Urban Improvement Act within bracket hereinafter called the Improvement Act bracket close rather than under the Acquisition Act because the acquisition proceedings were commenced before the Urban Improvement Trust, Jaipur was constituted. Stop.